Good day, and welcome to the Patently Strategic Podcast, where we discuss all things at the intersection of business, technology, and patents. This podcast is a monthly discussion amongst experts in the field of patenting. It is for inventors, founders, and IP professionals alike, established or aspiring. And in today's episode, our experts help to demystify the concept of common ownership and how it can be leveraged to disqualify prior art that might otherwise cause a rejection during prosecution. Dr. Ashley Sloat, President and Director of Patent Strategy here at Aurora, leads this discussion along with our all-star patent panel, digging into common ownership exceptions, joint research exceptions, and terminal disclaimer practice. And if this all sounds like a foreign language, or if you're wondering why you might care, do stay tuned for a primer that will help you quickly get up to speed on key concepts like inventorship, ownership, assignments, prior art, and terminal disclaimers. One of the recurring themes of this podcast is helping inventors avoid sharp corners, and we've found that these concepts in particular trip up a lot of newer inventors, and the resulting problems that come from misunderstandings around these core concepts can be very difficult to untangle later. Ashley is joined today by our always exceptional group of IP experts, including David Cohen, Principal at Cohen Sciences, Shelley Couturier, Patent Strategist and Search Specialist at Aurora, Amy Fiene, Patent Attorney at Vancott and Adjunct Professor at BYU, and David Jackrell, President of Jackrell Consulting. Now about that primer. After giving the group discussion a second listen, we realized that there might be some gaps for some folks in the audience. And when that happens, we like to front load the episode with some extra context. I'm joined now by Ashley, who's going to help answer a few questions to get everyone on the same page before we dive into the thick of all of this. To understand the implications of common ownership, it's helpful to know how ownership is defined in the patent world, and also how it relates to inventorship. Inventorship and ownership are really two sides of a very similar coin as it pertains to patenting and who owns the idea and has the exclusive rights to practice it. Understanding how these concepts differ is critical to protecting your IP and avoiding costly legal disputes down the road. All right, Ashley. So toward the end of season 1, we did an entire episode on inventorship that listeners should definitely check out. But at a high level, what is inventorship?
Absolutely. So the U.S. Constitution grants patents to inventors. And so what that means is that without additional legal frameworks, a patent will be issued to an inventor. And inventorship is dependent upon who conceived of the invention or who conceived of the idea. And even more so, taking it one step deeper, the claims of a patent define the metes and bounds of what is being protected. So if somebody contributed to one of those claims, they are determined to be an inventor. So just pure reduction to practice, so pure implementation does not necessarily make you an inventor, but it can if that implementation resulted in inventive concepts. So for example, just the way you actually implemented the manufacturing process actually did result in it being inventive over existing methods, then you would be listed as an inventor, even though you were taking somebody else's idea and implementing it. And so I guess, to say it, in another way, just because a company is paying inventors to invent for them or paying employees to invent for them, make new products, make new inventions, that does not necessarily mean that the company has the rights to the technology. It does rest in the inventors until the inventors assign their rights to the entity.
Okay, that makes sense. So we'll get into the topic of this podcast, common ownership, in a little bit. But before we do that, could you explain what ownership is?
So ownership is the entity that has the authority to file patent applications, at least under the America Invents Act, and take action in that pending application. So I think the most important aspect of that is that it's the owner that can enjoys all the rights of the patent, the right to exclude, the right to prevent others from making, using, selling, offering for sale, or importing the claimed invention. Now, the inventor can be the owner, and that's the first instinct, is that the inventor is the owner. But if the inventor assigns their ownership in the technology or in the patent to a company, then the company becomes the owner. Or you could even assign it to another person, right? You could, assign it to anybody, probably not your dog, but you could probably assign it to anybody or any entity. And then that entity now becomes the owner and has the right to kind of direct events related to that IP. And this is really, really important. There's been tons of case law around things not being done properly, and entities or people thinking they own something and then coming to find out that they actually don't own it because things weren't done properly. So it's definitely an often confused, balance between inventorship and ownership.
All right. So in a situation like with an independent inventor, that's obviously pretty cut and dry. You have the idea, so you own the idea. But it also seems like things could get a little bit more complicated when we start talking about companies with employees or contractors who are doing the inventing. And it sounds like you were alluding to this earlier for sure. But if I'm understanding this correctly, the implication is that just because I own a company and pay employees or contractors who come up with ideas, that doesn't automatically give me ownership and the rights of the IP, correct?
Correct. So as I, said, the inventor and the owner are the same person without any kind of legal framework behind that. So just because you're paying an employee does not necessarily mean that you then have ownership of the idea. Ideally, employees will assign their rights to a company so that that company can actually own the intellectual property and then do what it wants with it. And then they can, then license the patent rights and do things like that. But ultimately, without some kind of legal framework, a legal tool, the inventor is going to be the owner.
So then if employee inventors or contractors didn't assign their rights to the company, those inventors could profit from the invention, even if no longer working for the company, right? Like they could license the patents without sharing the royalties with the company. They could even become a competitor and sell a competing product.
Absolutely. And there's, like I said, there's been a lot of case law around that too, where even, where it gets kind of gray is an employee who left a company and they obviously conceived of ideas at the company, but then maybe they conceived of ideas afterwards, but maybe there's a continuum of ideas there during what was at the company versus what they did independently. And then, so how do you establish what was done at the company versus what was done independently and make sure that's clean and that you don't end up with an issue of somebody trying to benefit from something that the company paid for and they were contractually obligated to assign versus, somebody having the rights to their thing that they did independent of the company. And so just, making sure those lines are clear. There's been a lot of case law around that where things, were maybe not as clear as they needed to be, or there was some gray area there.
So very high level, what's the process then for transferring those rights?
Well, it starts at minimum with employment agreements, right? Every employment agreement should have a work for hire provision and or an assignment provision where it says something to the effect of the employee hereby assigns or has an obligation to assign, any rights in intellectual property that was created as a result of their employment with the company. And so it needs to start there, honestly, because when the second thing doesn't work out, which I'll tell you about in a second, when that second tool doesn't work out, we fall back on the employment contract. So the employment contract really has to have an assignment provision in there. So I would say this is highly important, even for super small companies where it's just you and your buddy. You should make an entity and assign all rights to that entity. So, worst case scenario, you and your buddy don't get along anymore. At least there's an entity that has the rights and that you can, then equally somehow separate from that company or get benefits from that company. It's kind of separate from the individual. So in the world where, God forbid, you don't have an assignment provision in your employment contract, what we will always do is an assignment for the patent rights. So when you file a patent application, there's essentially 1 to 2 page assignment that basically says the inventors assign their rights to this entity. And it's pretty much common assignment language. There are some special assignments that you can do, but most of them are pretty boilerplate. And it basically just says that the inventors assign their rights to this entity, or they assign their rights to this other person, or whatever the case may be, or this entity assigns their rights to another entity. So the assignment is kind of the legal tool that's used by a lot of practitioners like myself to make sure that the inventor's rights are assigned to an entity. And so we will all do it almost 95% of the time, the other 5% being inventors who don't have an entity, don't want to assign, because it's just them. But even in those scenarios, I would actually recommend that inventors put their IP and their company into an entity just to kind of create a firewall between personal and business assets. And so I think it's honestly a good practice no matter your size.
Okay, so inventorship is the conception of the idea, and ownership is by default. Ownership is possessing the rights and benefits of the granted patent, and assignment is how we get those rights from one to the other. This is a pretty solid baseline, but I'd also like to give the audience a high-level overview of common ownership, which is really at the heart of this episode. But to do that, we have to have an understanding of what prior art is and how prior art leads to Section 102 and 103 rejections from the Patent Office. I know this could be an entire episode of its own, but what is prior art and how does it pertain to these rejections?
Great question. So prior art is any evidence that is generally known to the public. So that could be websites, journal articles, materials from trade shows, even dissertations, material from books, obviously patent documents, right? Issued patents or patent publications. Really anything that, like I said, is publicly available. Again, there's definitely been case law around what, how generally available to the public does it have to be to actually count as public art. But suffice it to say, a dissertation that you can prove that was never checked out at the library still counts as a prior art to your patent. So, it's pretty strong. Basically, if it's out there. And so when an examiner gets your patent application, he or she basically reviews the claims and does a search through the prior art, through all these different databases. And if they find something that they believe is related to the claims that are on file, they'll basically give you a rejection in the office action. And so the rejection is around the ideas of industrial applicability, which almost everything has utility, right? So that's a pretty low benchmark there. But then novelty and inventiveness. And so they basically will give you rejections based on those grounds, and a few others, of course. But for prior art, it's mostly these two. And so these novelty and inventiveness, or non-obviousness, as we call it in the U.S., these are in the U.S. code as 102 and 103, sections 102 and 103. And so it's usually through these two avenues that the patent examiner will reject your application, and then it becomes kind of a bartering process, or a back and forth argument process to prove to the examiner that your invention is indeed new and non-obvious over any prior art references that they found.
And that takes us nicely to common ownership. What is common ownership, and what's the interplay with prior art?
Yeah, so this topic is pretty thick. And honestly, I feel like you could look this up in several different places and have a slightly different interpretation, no matter who you read. But, suffice it to say that we're going to focus on the America Invents Act. We're not going to focus on pre-AIA because it further conflates the topic. But suffice it to say that there are situations in which you've created your own prior art. Right. So that prior art could be either public disclosures, or, like you've presented at some pitch event, or it could be a journal article that you published, or some kind of sales activity that you did. So that's one kind of disclosure, right? That could create a problem for you. And so in those situations, if the examiner finds that material, and obviously if you know of those things, you should disclose it to the patent office. So let's say they see this activity, and if it falls within a 1-year grace period, within 1 year of your filing date, there is an exception under 102A1. And so that's one type of the prior art rejection would be 102A1. And the exception is a grace period exception of up to 1 year for disclosures that you've made, right? You've essentially made your own prior art. But there's additional prior art under 102A2 that, in this situation, if you, again, have created your own art, but in this case, it would be a patent application. Let's say we're part of a company and we patent lots of things, and we patent lots of iterations of things. So let's say that prior, to our filing date, we had filed patent applications directed to a first generation product. And let's say, later, after that filing, after that original patent application publishes, we file another patent application that's an improvement of that technology. And so in that case, again, the examiner may find this prior publication, patent publication, and cite it as a rejection under 102A2 against your later filed patent application. In that scenario, you may be able to use a common ownership exception, basically showing the patent office that these two patent applications are commonly owned. Now, most generally speaking, that prior art publication, patent publication, needs to be within 1 year of your filing date. There are some probably crazy rare circumstances where it could be greater than that. But once you get greater than that 1 year exception, now that prior art falls under 102A1 and is no longer available for the common ownership exception. So this is where it gets really muddy. And so that's why, essentially, suffice it to say in a really easy way, there's two exceptions. Under 102A1, it's, a 1 year grace period. Under 102A2, it's essentially, a common ownership exception with most likely within a 1 year time frame. And that's the most common ways you're going to come across that. And so in order to disqualify that prior art due to a common ownership exception, you have to be able to prove that the prior published patent application or issued patent, and at the time of filing, and your later filed patent application at the time of filing were under common ownership. And that could be under an obligation to assign based on contract language from your employment contract, or it could be due to an actual assignment that was filed. And some examiners can request additional information. We had one case a number of years back where we had an assignment on file, but the assignment wasn't filed as of the filing date. It was filed a few days later with the patent office, just, the logistics of getting inventors to sign things. And so we actually had to go and prove from employment contracts that they were under an obligation to assign as of the filing date. So again, that's where having both of those pieces of proof is helpful. So that's kind of the thick and the thin of it, if you will.
A lot of dots to connect to get there, but I think that's super helpful. Toward the end of the upcoming discussion, you and the panel talk about terminal disclaimers and double patenting. Could you briefly explain both?
Yeah, usually double patenting leads to terminal disclaimer filing, but not always. But there are two types of double patenting. And basically what it comes down to is the whole part of the patent system is that you publicly disclose your technology in favor of getting a limited monopoly from the government to benefit from that invention. But then it promotes the progress of the useful arts because people can read about your invention and build upon it, right? But you still have that monopoly of the base invention. But there are some cases where maybe through continuation practice in the US, or because you're iterating on a technology that a later filed application is really similar to an earlier filed application, or maybe just even claim sets arising from the same disclosure are highly similar, right? So you could end up with really similar claim sets or really similar offenses around your invention, but maybe slightly different. And the patent office doesn't want you extending your 20-year monopoly by doing these different things to kind of extend that 20-year time frame. And so when they feel like two patents could protect essentially the same invention, what they give you is a double patenting invention. And sometimes it's a statutory one, which is not good. That basically says this is the same thing, not okay. In a non-statutory double patenting situation, they say that this is an obvious variation of this other one. And so you're basically trying to patent the same thing twice in a slightly different way. And so maybe a slightly different scope, but still not okay. And so what they basically say is that for the later filed patent, any patent term that extends beyond the term of the earlier filed one needs to be you basically are saying that doesn't matter to me and you can take that away. So let's say the parent patent was going to expire on today and the later filed patent was going to expire 10 days later. Your terminal disclaimer basically says, I'm okay with you taking away those 10 days. If you give me these two patents, you can take away those extra 10 days. And so that's what a terminal disclaimer essentially does. And so it's a way of just saying to the patent office, I want these 2 patents, but I'm okay with them having the same patent term.
Fantastic. Thanks, Ashley. And with that, we will kick it over to the panel.
So today I was going to talk about prior art and common ownership and all of that good stuff. Where that kind of started is I had some cases come up where, it just seems like more and more nowadays people are sharing and selling stuff and doing things that they shouldn't do before we can help them. And so I was kind of curious about the common ownership piece. I think David Jackwell, I think you and I had talked about it at some point too, and just were like, what are all the provisions around that? And so it was kind of an interesting little journey through some of the stuff I came to find. And so kind of started out with common ownership, but then kind of went through some joint research stuff and then kind of ended on some interesting terminal disclaimer practice stuff that I think terminal disclaimers we kind of take for granted. I think it's just like you see one of those come up and you're like, oh, just file a terminal disclaimer, no big deal. And there's actually some more interesting things that I think we don't always think about when we're doing that. And so that's kind of the interesting end to all of this. So I'm going to go over, obviously some of the things that we readily know around inventorship and ownership. But part of the reason I put these 2 up here at the beginning is that I feel like there's been a growing misunderstanding, at least from clients, of what inventorship means versus what ownership means. I have some clients who, are concerned when, you're talking about, they think that because they're the owner of the company, then they start to be confused around why you would list people who worked on the technology as inventors. Because then they feel, then they're like, well, then I don't own the technology. And you're like, well, no, you do. Your company can, as long as it's assigned to the company. Or you have, different companies making agreements with technology firms. And again, their company owns the technology because they paid a firm for it. But then they're not understanding that individuals at that company who contributed substantively to their technology should be listed as an inventor, and it doesn't take away your ownership. And so we've had some really weird things lately around that. And so just kind of wanted to start off with that distinction. So as we all know, inventorship is who conceived of the invention, and reduction to practice might not matter, especially if it's really just, somebody receiving technical drawings and making it. Whereas if you're conceiving as you're reducing to practice, then of course, then that reduction to practice counts in terms of inventorship. And there's obviously a lot of gray area in there, but, and then from an ownership perspective, so with the America Invents Act and in 2012, the original applicant is presumed to be the owner. So that's like the person you list on the application data sheet, right? Pre-AIA, it was presumed to be the inventors, but then, and still today you can transfer ownership, appropriately to whatever entity that you deem appropriate. And so, so that's, all the inventors, could own the technology, but then, you can have them assign it to an entity so that the entity owns it and can make decisions for that patent application. So then, from a general overview for going deeper into the ownership side of things, obviously a brief overview or review of AIA 102 prior art, and then some of the common ownership exceptions. And if anybody has any experience with this or feedback, love to hear it, because it is, I think there's, just as we find with every area, lots of gray area. Joint research exceptions. I don't have a ton of experience with, a lot of joint research endeavors. And then some interesting terminal disclaimer practice that kind of stems from these. So for AIA prior art under 102A, the first part of it, 102A1, is all around publications, patented, printed publication, or in public use or sale prior to the effective filing date of the claimed invention, which the effective filing date now, as of AIA, is the date of the filing of your earliest application that includes the invention. And so, it's really anything in the world. And then 102A2 is the claimed invention was described in a patent issued or an application that was published or deemed published, in which it, names another inventor, and again, was effectively filed before the effective filing date of the claimed invention. So kind of basically, it's the whole on sale, in use, published, printed. That was, and again, you could go a whole discussion around what is considered prior art. 'Cause there's been lots of discussion around that, right? How was it actually available to the public? Was a dissertation that sat on a library shelf that never got touched, never got checked out? Is that prior art? So obviously a whole discussion around that we're not going to go into today. But so the exceptions that relate to these, so you have 102A1 and under, so for exceptions for this one are under B1. So these are the issues when you have a client that within a year of their effective filing date, they have sold it, published it, or somebody got it from them and published it or sold it before the effective filing date. So it basically says, disclosure is made 1 year or less before the effective filing date of the claimed invention shall not be prior art if the disclosure was made by the inventor or joint inventor or obtained from the inventor or joint inventor, or the subject matter disclosed had been publicly disclosed by the inventor or a joint inventor or another who obtained it. So again, it's coming directly from the inventor in some way, shape, or form, but 1 year or less before the effective filing date. The 102B2, which is exceptions for 102A2, are that disclosures appearing in applications and patents shall not be prior art if the subject matter was disclosed, again, directly or indirectly by the inventor. Actually, they're very similar, as you can see, to the first one you just described. And then also this one brings in the common ownership. So the subject matter disclosed not later than the effective filing date of the claimed invention was owned by the same person or subject to an obligation of assignment to the same person. So, and although this one does not say 1 year or less, through lots of scouring, talking to some other people, this also applies to a 1 year timeline. So if it's more than that, you're out of luck. The other interesting thing that I've seen, personally, we haven't dealt with this a ton, but we do on occasion have it, is that, as just all things do with the patent office, it varies heavily by examiner. We have had some cases where you can essentially just make a statement in a response that as of the effective filing date, these two, this prior art reference and the current application were co-owned or subject to an assignment or, obligation of assignment to the same company. But we've actually had an examiner that in one case, as you do sometimes, you don't have all the signed paperwork at the time of filing just because things happen, inventors are slow at returning documents, all that kind of stuff. We've had it where we file an application and then a few weeks later, a few days later, you file the assignment. And so that assignment then is recorded a few weeks later, a few months later with USPTO. And we actually had an examiner at some point basically look at the assignment record and say, well, as of the assignment record in the USPTO, it wasn't co-owned. And so we actually had to go back to the client and find their company agreements with these inventors that actually showed that they indeed had an obligation to assign. And so I think that just, I have some practical tips at the end, but I think that just further goes to the point of stressing to clients when at all possible to have agreements in place, because I think it's so easy to start working with somebody, especially in contractors and tech groups and things like that, before having agreements. But then you get into this situation where the examiner doesn't take your statement at face value. They want more information and you don't have it.
Good point.
Yeah, and so this kind of goes, so some of the cases that I found around common ownership with the PTAB, the Patent Trial and Appeal Board, so a lot of times you can make that statement of owned or subject to an obligation of assignment to the same person or entity as of the effective filing date. But then the PTAB has, at various points, required objective evidence of such assignments, such as assignment documents, corporate records, employee agreements, contracts, and even employee pay stubs to prove that there was indeed common ownership. So I think, again, that just goes towards, not playing loosey-goosey with, having contracts in place. And I know it's easy to do, but it can be really important. As you'll see too, I go through some, actually here, the next slide talks about common ownership and how it does not necessarily include subsidiaries. So there was a PTAB case where Crop Science AG owned Bayer Crop Science NV and Biogen IDEC NA. So basically had a parent company and then two subsidiaries. And so when the examiner looked at the case originally, he construed the commonly owned to include that the assignees were wholly owned subsidiaries of a common owner. So again, all of them, kind of worked together, had, in his view, had kind of ownership over the patent portfolio. And so, but they were trying to argue that there wasn't common ownership because I don't believe they didn't want the terminal disclaimer. They didn't want to lose some of that patent term. And so there was Lehman's patents that were rejected for double patenting over two Strauss patents. The Lehman's patents were co-assigned to both Bayer Crop Science and the Biogen company, which were the subsidiaries, and the Strauss patents were assigned to the parent company, the Bayer Crop Science AG. And so what the PTAB had determined was that the Lehman's and Strauss patents were not commonly owned because under U.S. law, a parent company does not own or have legal title to its subsidiaries' patents, even when the subsidiary company is incorporated in a U.S. jurisdiction. So there is, you would still have to seemingly assign patents or license patents between the subsidiaries to create some kind of co-ownership relationship. And so in this case, they were, subsidiary companies and that parent company did not have rights to those patents. And so for that reason, a requirement for, terminal disclaimer or, double patenting, basically they would still have to be able to show non-obviousness over those patents, but, there was no requirement then to have to do a terminal disclaimer. And that one of the interesting things that the PTAB had said is the legal authority and evidence for patent owners that patent owners must rely on to support their position that an overlap in ownership does not exist between Lehman's and Strauss patents is more persuasive than the examiner's public policy justification. So the examiner was kind of saying, well, look, the whole point of this, he's kind of saying, this was it was a loophole to skirt the whole issue that you don't want companies extending their patent term unfairly by having these really highly similar patent applications or patents issuing. So then effectively your 20-year term becomes a 25-year term. And they said, we understand your public policy justification and we don't necessarily disagree with that. But, the patent owner basically, they were right in the sense that, based on U.S. law, that that overlap in ownership does not technically exist. So I thought that's interesting. I'm sure there's also cases, and actually the next one is a little bit different, but kind of similar, where common ownership does not necessarily include exclusive licensees either. So there was a court case with the Federal Circuit, Immunex v. Sandoz, and so the parties, patent owner Roche, an exclusive licensee, Immunex, the alleged infringer was Sandoz. So again, Roche is the patent owner, licensee is Immunex. So Roche and Immunex are kind of in a relationship, some kind of potential common ownership, and then the infringer is Sandoz. And so there was an accord and satisfaction agreement between Roche and Immunex. And so what Sandoz was trying to argue was that, again, there was, common ownership because of this agreement. So there's, terminal disclaimer, and, different, patent term. And so, and it probably, invalidity because of that. So Roche had so what the Federal Circuit had determined was that as part of their accord and satisfaction agreement, Immunex, originally as the exclusive licensee, had all rights to sue. However, if Immunex had decided at any one point in time to not sue, then that interest fell to Roche, and Immunex could not rectify the infringement or frustrate Roche's efforts in that regard. So once the rights to sue fell to Roche, there was nothing Immunex could do to change it, right? Because they decided not to, and Roche decided to do it. So the Federal Circuit said because that Roche could still retain their rights in the event that Immunex decided not to act, that they still had some control over the patents. And so so then, basically this differentiated from seed play versus bebop, where the licensor retained right to sue was basically didn't really exist because the licensee could nullify their right by granting the alleged infringer a royalty-free sub-license. So it was one of those things where because Roche could, have the right to sue, they still fully owned it. So there was no common ownership because Roche completely still had ownership of the patents. They just had this license with them, but they still had full control in the event that Immunex decided not to pursue it. And so again, it just really comes down to the devil in the details about how these agreements are structured. If your licensee has full control, and even if they decide not to take control, you still have no rights to do anything about it. Or if you, as the licensor, decide to take control, but they can frustrate that by doing some kind of license, then, you really don't own the patent anymore. So I think that was kind of their takeaway. And so I think it's just, again, it's not as cut and dried. I mean, I think most clients that we work with are pretty cut and dried, right? It's one company that's, having license, but it can get sticky. I mean, I know we even have a client that has a US company and then a Belgian company, and we assign most of their patents to their Belgian company because they get tax benefits in Belgium. But then that creates a problem now because if some of them are retained by their US company and they have some with their Belgian company, you then have to be able to prove common ownership between those entities if you were to want to overcome some kind of obviousness type double patenting. So I think it's can be kind of screwy. And then, so the other common ownership is under joint research agreements. So the subject matter was developed in joint research agreement. And the claimed invention was made as a result of the agreement. And the application for patent discloses the names of the parties to the joint research agreement. So that can also be a common ownership. And so what they have regarded as joint research agreements, obviously a written contract, some kind of grant, some kind of cooperative agreement. And obviously it can be in the experimental field, developmental research work. And I think some of the interesting things that come out of this, so now it's more complicated, right? Because it's not just one company or a company with subsidiaries or a company with licensees. Now you have like two parties or more who effectively own it, right? That have some part of the pie. And so now, and who are kind of potentially could be at odds with one another at any given point. And so from a terminal disclaimer practice, so again, to overcome that obviousness type double patenting, and you do a terminal disclaimer, you are basically waiving the right to separately enforce any patent granted on that application, right? So you have the disclaimed patent and the disclaimer patent. And if those are ever sold separately, you can't enforce them. So I think that gets really sticky from a joint research perspective, because if company A all of a sudden decides that they're going to pursue more heavily company or technology X from this joint research, and company B decides that they're going to more heavily pursue, technology Y from the joint research, and they kind of go their separate ways. Now you've just, and those were terminally disclaimed to one another. Now you're kind of breaking that link between them, and you might not be able to enforce those patents at some later date. And so under the CREATE Act of 2004, two patent applications of different ownership are considered commonly owned if the invention at issue was made pursuant to a joint research agreement, the invention was within the scope of the agreement, and the parties to the agreement are the applicants of the application. So again, this goes towards having really good agreements in place of what each company brought to the table, what each company created as a part of this development. Because otherwise, if that's not really clearly spelled out, I think it could have really problematic, what happens with, their existing portfolio that they bring to the table versus something that they share together. And so, from, so kind of going back to this whole, terminal disclaimer, this kind of so it's been a kind of a crazy route through some of this stuff, kind of coming across different things. But so some of the terminal disclaimer practice that kind of came across, which is that, the one-way test, which I think is what most examiners do, is very much the default, is whether the asserted patent is obvious over or anticipated by an earlier issued patent, right? I think that's like a commonly, when you're prosecuting, that's kind of commonly what you see, right? But then there is a, rarer two-way test where, for whatever reason, a second filed patent application issues before an earlier filed patent application. So they're kind of, even though one was filed earlier, for whatever reason, it ends up issuing later. And this is usually, this has to be because the PTO is responsible for the delay in the issuance of the first filed application. And so in those cases, there may be some kind of, more interesting terminal disclaimer practice because, they still may be obvious over one another, but one typically has an earlier date. So then how do you rectify that? Because you can't, and I'd have to do more homework, honestly, on the two-way test. I think it's quite rare. Well, obviously it's very rare, but I don't know how they rectify it in that situation, because you have one that issues and you can't cut short. So I guess you could cut short that one. In theory, you would cut short that one relative to the other one if they were co-owned then, or part of this joint research agreement. But then the examiner would have to be aware of this other one, assuming that one was published, right? So I think it's a weird chicken or egg thing. So I don't know.
And if the PTO is responsible for the delay, there could be a patent term adjustment, right? So
right. Further extended.
More complicated.
Yeah. But then there's also the safe harbor, which, I guess it makes sense. I just never really thought about it. But that when you have an obvious type double patenting rejection, that this wouldn't apply for divisional applications, right? Because a divisional, in theory, it's kind of a different invention anyway. So the office has already kind of said, these are different. And because they're different, pursue it in a separate application. But, if you ever got a obviousness type double patenting rejection in divisional, it's improper. There's a safe harbor provision around terminal disclaimers with that, because the patent office has already said this is different, pursue it separately. And then for an examiner to come back and say they're obvious variations of one another would kind of be against what they've already stated, I suppose. But yeah. I feel like, practitioners are getting smarter and smarter around avoiding restriction requirements in general. And so I feel like, I can count the number of times I've done a divisional, probably, because I feel like you try to avoid the issue altogether. But anyways, so yeah, a lot of weird things. So I guess kind of the things that came up in terms of like practice, is that when at all possible, ensuring the assignment is filed the same day as the application. I know that's really difficult sometimes, but I think, what we had learned with one of our clients was just any way that you can button up things to make it Loctite in terms of when things were owned, and not having to delve into contracts and agreements, that you have to look through and redact or, put on file and stuff, the better. And then we've actually had this come up, for multiple reasons lately. I don't know what it is, but that verifying that clients have agreements in place around who owns the IP. We've had, obviously this poses problems not only just from like an ownership perspective, from how do you assign it when you're doing these activities, but then longer term, if there's ever a common ownership play to be made, you have to know who should have owned it at that time as well. We've had clients that have entered into development agreements with firms that they're paying with the internal understanding that because they paid a firm to develop this technology for them, that they own it. But then you have the firm come back and say, well, look, we used our base technology to develop this for you. And because of that, we own it, or we own a portion of it. And that could have all been solved had they had an agreement in place that said, this is your base tech. This is what we asked you to do. This is what we developed together. And because we paid you for it, we own it. It was our idea. You just reduced it to practice, or, or whatever the case may be. So some sticky things. And this doesn't come up, crazy often, but I think it's something, when you're starting to do reports for clients around diligence or licensing or things like that, make sure you clearly label when patents have been terminally disclaimed and which are the disclaimer patents, because There's an individual that I've been working with for another client, and he said it's a really interesting negotiation piece. He said you'll see that really savvy sellers and buyers, that if for whatever reason the seller didn't disclose the terminal disclaimers or forgot to or didn't realize it, whatever the case may be, the buyer who notes these terminal disclaimers will kind of keep it to themselves until like the 9th hour and then throw them on the table and be like, ha, there's terminal disclaimers. And if those if some of the disclaimer patents are in a different family, now for that buyer to be able to enforce the patents that they're purchasing, they also need a license or something, or you'd be able to purchase those other patents. And now because it's the 9th hour, they can get them at dirt cheap because, the clock's run out, right, on the agreement, or everybody's kind of, over it. So I think the more that, we remember or include those details around terminal disclaimers, I think it's better for everybody. It allows clients to hopefully get more maximum value for their portfolios. And then this was an interesting thing that I had, again, I think at least, I've always kind of felt in some regard, I don't take it, in a cavalier sense, but a lot of times these terminal disclaimers come up, for me at least, in continuations, right? Where they're already essentially have the same patent term because they're all stemming from the same priority date. So PTA, your patent term adjustment, may play into that a little bit, but you're looking at like 70 days difference, 90 days, whatever. But in cases where it's more substantial than that, some practice tips that I read were, really making sure that every single claim was rejected for an obviousness type double patenting. And if some weren't, consider letting those pass to issue, and then consider going back at another bite at the apple for the other ones to try to argue that they're distinct, or that there's or change them a little bit to make them more distinct, so that you can avoid the terminal disclaimer, maybe have different claims of varying. So I just thought that was interesting. I think it's just, I think a lot of practitioners, myself included, until I thought more about this, was just, oh, terminal disclaimer, it's only 90 days. Like, what's the big deal? But as those terms start to differ more drastically, thinking about it more, and not being afraid to make, some arguments back, or letting some of them pass to issue. So anyways, I know that's kind of all over the place, a lot of different kind of topics, but kind of all related. So if anybody has any thoughts or personal experiences, or.
I have a question. Thanks for this. It's a great topic. I think it's really interesting. And my question is you talked about 102 commonly owned issues under a 102 rejection. Is there any difference under a 103?
No, you're right. So I forgot about that part. Yes. So I didn't include that, but yeah, so it does apply to 103 as well, but the art cited as part of the 103 has to be under one of those 102 sections, which it normally would be, because that's the only sections of 102 now with AIA. Whereas I think pre-AIA, it got a little more interesting. So there's only certain sections of prior art that would apply to the common ownership.
Okay.
But now with obviousness as well, it does apply.
So you still have a common ownership exception, even for 103, only works within 1 year grace period.
So I went round because I read so much about this, and it was like blowing my mind, because some things I read said, that if it's more than 1 year, stop now, there is no exceptions. But then when you really read the statute, the first part is, it says like 102A1, and then these are all the exceptions for under, 102A1 exceptions are the 102B1 exceptions, which says, 1 year or less, blah, 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 blah. And then you have 102A2, and all the 102B2 exceptions apply for 102A2. And there is no statement of a 1 year period. And so in my mind, I'm like, there's no statement of a 1 year period. Like, it seems like if it were longer than that, it should still apply. You might be opening yourself up to some kind of terminal disclaimer, losing a lot of patent term. But then, like, I was conversing with an attorney that works at a firm that we do some shared work with. And he, because a case came up ironically where it had been more than a year, where a client had a published application and then one that we were filing, or it was like an office action, right? So they were like separated by more than a year. And I said, I'm like, could this apply in this situation? And he said he had delved into it recently a ton for a separate case, and said that the 1 year applies for everything. And so like I said, I mean, based on the MPEP, it seems like it doesn't, but seemingly how people are interpreting it is that, so I don't know. I'd be curious to almost press my luck a little bit with an examiner at some point and just be like, so, greater than 1 year, does this apply? But anyway, so that's my understanding, all 1 year or less. So I guess, which does make sense, but in the sense of like the terminal disclaimer, I feel like you should be able to commonly own thing if you're willing to disclaim a whole bunch of patent term, like what do they care at that point? You know what I mean? If you had things that were separated by 3 years, for example, a published application and then something that was earlier issued or whatever, and they were separated by like 3 years, if you're willing to terminally disclaim those, then what does the patent office care that it were 3 years?
Maybe I'm wrong. I thought you can, I thought there was no grace period for a terminal disclaimer if it's a double patenting rejection.
Right. But I was meaning, I guess, more common ownership. If it were commonly owned,
right?
Why would they care if you were willing to disclaim?
I think I think maybe I'm missing something, but I think at least in some scenarios, if the claims are coextensive, then it's a double patenting rejection. But if you have this prior art reference that doesn't claim it, but just discloses it, now you can't terminally disclaim it anymore because you haven't.
Right. Oh, yeah, that's true. Right.
Equivalent claims.
That's true. Right. It's just, yeah, that's true. That's fair. Yeah. Because it's not the claims at that point. It's the disclosure of it. Yeah, it's true.
Yeah. I thank you for all your research on this. It's really helpful. And because this has come up for me a couple of times, and people I work with are like, no, we can't. It's been more than a year, co-owned. But I have these like random tidbits from other practitioners and from, the bar exam, whatever, that it's like some things are prior art for novelty, but not for obviousness. And I thought it was this common ownership thing because I remember working with other practitioners years ago, and this is my issue, and I need to go back and look probably more too, but that something was about to publish and we were, not scrambling, whatever. We were working to get something on file because it was going to be prior art for novelty, but not for obviousness. So we could still do et cetera, et cetera. That was part of the whole strategy. But now I'm kind of trying to figure out what that situation was, because this was a very experienced attorney who was telling me this, or was setting the strategy. But I can't remember what the situation was. So.
Yeah, I have to go look now again more. Like I read like countless blogs, but yeah, because I've seen it come up. Like we had a client where I always tell clients it's like a good issue in some regard, right? When your own art is the only art being cited, right? Because that means that you're kind of occupying your own space, right? That like nobody's moving in there. Then also in the other sense, it creates a lot of problem because you can't argue against yourself. At least you shouldn't a whole bunch. So then, but we've had these situations where, the only rejection we get is, 103 with our clients' prior stuff. Mm-hmm. And they're definitely co-owned, but, and usually examiners are pretty on top of this stuff because they're usually in the off sections will say, I do note that it is commonly owned, hint, hint. Yeah. And I haven't seen it in those cases where it's, we did have the case where it was 1 year or less. The examiner definitely gave like the hint. I noticed that some of the inventors are the same. If you could prove common ownership or whatever, or this is more like, I guess, disclaiming it just because they were the inventors that publicly disclosed. I guess that was that case. But in this, so I don't know. I need to now I'm going to go back to, and I'll send something out through email if anybody finds, or if you find something, David, because now I want to revisit in my throwing this together, I kind of forgot about the obviousness angle. And if maybe that has more latitude in terms of time frame. Because maybe that's where the latitude comes from. But again, I was really surprised. Like, again, if you go back up here and look at this So this is the exact MPEP language for exceptions under 102A2, and there is nothing around 1 year. If you go to the top one, it says 1 year or less, but that's not applying to all of the sub, it doesn't apply to 2 because 1 is separate from 2. So I don't know. I had really convinced myself during this research that there was no 1 year, but then after talking to Albert, I was like, okay, maybe I'm like missing something. So I don't know. I feel like I need to test the waters or something, like just throw out a common ownership statement at some point and be like, what do you think, examiner? Let's discuss this, because I don't know. Yeah. No, left you with we solved all the world's problems and now we can't solve a problem in patent law. Who knew that was the toughest problem? So anywho, so I'll keep on diving into this a little bit because now it's puzzling me.
Well, thank you for taking on such a arcane and
Well, I hope it was clear. I felt it like it was a little
right. No,
loosey-goosey, but
I've been trying to avoid this for a long time,
Well, we still didn't solve it fully. Now we have, so I don't know. Well, it's still like
more questions to answer.
I know. It's what keeps you up at night, right?
Super helpful. Thank you, Ashley.
Yeah. Thank you, Ashley.
Yeah, thank you.
Yeah, no worries.
I learned a lot. It's easy in corporate, right? Corporate already has all this stuff set up. So
right. Yeah. A small guy's got to figure it out ourselves.
Yeah.
All right, everybody. Well, have a good rest of your week and we'll talk to you later.
Thank you, Ashley.
Thanks.
Thanks. Bye, guys.
Bye.
Bye.
Till next time. Bye.
All right, so we're going to insert just a little addendum here at the end. The group ran into a question around whether or not the 1 year time frame or grace period applies to the common ownership exception. We hit on this a little bit in the intro, but just wanted to make it really clear in case that got lost a little bit. So we researched this issue further post-recording. Ashley, what did we determine?
So kind of going back to section 102 of the US Code, right, that basically codifies novelty, the parameters of novelty in the US in post-America Invents Act. There's basically 102A1 and 102A2. And these two sections enumerate the kinds of prior art that fall into these two categories, okay? And with that, there are exceptions to the prior art for each of these categories. So for 102A1, there is a grace period exception of, up to 1 year. If you do a trade show, some kind of literature publication, you can, if it's within 1 year, you can say it doesn't count because I'm the inventor, I publish it, my bad, it doesn't count. For 102A2, there is technically no time limitation. Okay, if you look at the MPEP, you look at the US Code, there is technically no time limitation to exceptions under 102A2. There is a common ownership exception though, right? And that common ownership exception says that if the prior art document and the instant patent application are commonly owned as of the time of filing, then that prior art under 102A2 doesn't count, right? However, there are going to be scenarios where art under 102A2 would also be considered art under 102A1. And that's going to be actually the vast majority of the cases, right? If you look at what kind of prior art is under each of those categories, the vast majority of times, if you get a 102A2, you're going to get a 102A1. So in that kind of case, then it has to be within that 1 year time frame. So even your common ownership exception has to be within that 1 year time frame. There's going to be a really rare sliver of prior art that is beyond 1 year and only under 102A2. And in that scenario, the common ownership exception has no time limit, right? It's however long ago. However, like I said, that's going to be the super rare exception. And I've talked to tons of practitioners, and most people will tell you that the common ownership has a 1 year time frame limit. And that's technically inaccurate if you look at the MPEP, but I think where everybody kind of believes that is just because it's so rare to find a piece of prior art from a common ownership perspective that wouldn't fall under both of these sections. and thus require a 1-year time frame limit.
Well, it's a good thing we have experts like you to sort this all out. Thanks for the clarification.
Happy to do so.
All right, that's all for today, folks. Thanks for listening, and remember to check us out at aurorapatents.com for more great podcasts, blogs, and videos covering all things patent strategy. And if you're an agent or attorney and would like to be part of the discussion, or an inventor with a topic you'd like to hear discussed, email us at podcast@aurorapatents.com. Do remember that this podcast does not constitute legal advice, and until next time, keep calm and patent on.